Unless they manufacture, you know, and so the mind, Sati. So, when I get it, also. I want to get off. So, you came on the face of this way of class. It's very easy. Was 10 like that. Ah, 15 government, whether government had followed it, then acquisition process, due process. Whether question.
For judgment, item numbers 32 to 41.
These pages of writ petitions are analogous matter, so I'll pronounce the conclusion part. In light of the office memorandum issued by the Chief Secretary to the Government of Nagaland on 5/3/2025, and with the consent of the parties, this writ petition is disposed of with a direction to the respondent authorities to consider the petitioner's case for granting a scale of pay as per the revision of pay 2015 in accordance with office memorandum number so dated 5/3/2025 within 60 days from the date of receipt of the certified copy of this order. Stand disposed of.
Your list.
Yes.
I picked the agenda item 27 for hearing.
Item
27. After 2 weeks. Worship, it may be listed after
Item?
2 weeks. 27.
27.
Yes, Worship. I am for the respondents, Lordship.
Yes,
This matter be listed after 2 weeks, Lordship.
after 2 weeks.
My lord.
You have first petitioner. Okay. Mr. Yangarbati, Learned Counsel for the respondent. Prays for adjournment of the matter for 2 weeks. The prayer not objected. Accordingly, the prayer is allowed. List is matter after 2 weeks. Okay,
That's all, Lordship.
not objected to by the Learned Counsel to the petitioner, huh? Okay.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item 29 from the hearing list, Your Lordship. Your Lordship, this matter may kindly be listed after 2 weeks, Your Lordship.
It's a pension matter,
Yes, Your Lordship.
not released. Okay. So whether the
Uh,
petitioner is present,
Sure, but I had taken the consent in the morning, Your Lordship.
you've taken, okay, Miss
In the whole,
Now-
Your Lordship.
Learned Government Advocate appearing on behalf of the state respondent with the consent of the Learned Counsel to the petitioner. Prays for adjournment of the matter for 2 weeks. The prayer is allowed. List is matter after 2 weeks.
Much obliged, Your Lordship.
May I please, Lordship?
Yes.
Lordship, I beg to mention hearing item number 28. Lordship, my senior counsel, because of the personal difficulties, she could not be present today. So let this matter be fixed next week.
This is
Item
regard-
number 28. I'm representing respondent number 4.
You are for respondent number 4
Yes, Lordship.
and the petitioner is present. No objection.
Yes, yes, Your Lordship.
Okay, Mr.
Abel Ayemi.
Learned Counsel appearing on behalf of the respondent number 4. Prays for adjournment of the matter to which the Miss
Kim Piana,
Learned Counsel for the petitioner has no objection. Accordingly, the prayer is allowed. List is matter after 2 weeks.
Okay, Lordship.
Okay.
Lordship, I beg to mention item number here, admission item number 2 as well. Yeah,
Item 2,
yes, Lordship.
this otherwise is ready for hearing.
Yes, but
Can it be listed for hearing?
Lordship, my senior counsel could not be present today. Even this is
When do you want?
after a week, Lordship.
You are for the petitioner.
Yes, I'm for the petitioner, Lordship.
Okay,
I'm
Mr.
taking the consent from Mr. Abel Ayemi.
Bill, I am
Taking the consent from.
Learned
both
Counsel for the
parties.
petitioner with the consent of the Learned Counsel on behalf of the respondent. Prays for adjournment of the matter for a week. The prayer is allowed. List is matter after a week. Okay.
Oblige, Lordship.
Lordship, I also back to mention item 12 to 32. 32. 12 to 23, Lordship.
12.
These are 12 to 23. These are all.
So here counter affidavit not yet filed.
Yes, Lord.
Your Lordship, in this case, the notice of motion was issued in the month of June last year. So now almost 8 months.
Mr. Lima from Learned Counsel for the petitioner is present. Mr. Yangarbati, Learned CGSC.
Yes,
For filing affidavit.
I have not received any instructions so far, Lordship.
Okay, and
I'm for I'm for
Status
state
one.
respondent.
and then you
Yeah,
have
yes,
also,
we-
you have also not yet filed.
No,
Okay. Mr. Jimomi, Learned Government Advocate for the state respondent, and Mr. Yangarbati for the Learned CGSC. Prays for further, how much
3
time?
weeks.
3 weeks time to obtain instruction and to file affidavit in opposition. The prayer is allowed. List is matter after 3 weeks. Item 12 to
23, Lordship.
please, Lordship, I beg to mention item number 3 to 10.
here also, except for 1, 2, 3. Respondent state has not filed affidavit, it
My
appears.
lord, we have received instructions. However, certain clarifications are required still. So may I pray that I may be granted three more weeks so that I will file my affidavit.
Miss
Your Lordship.
Learned Counsel for the petitioner is present, staff. Mr.
LT Sankar.
Leonard, additional AG, appearing on behalf of the stressed respondent, submits that he had received an instruction, however, some clarification is yet to however, some clarification is needed, for which he needed
3 weeks.
he needed 3 weeks' time. And prays accordingly. The prayer is allowed. List this matter after 3 weeks. Okay.
Keep those blanks, please.
Just a minute. This is 3, 4.
3 to 10.
7, 8, 9, 10.
Lodge.
Okay.
Lordship, I beg to mention item number 11, Lodge. Item
They
number,
are also not yet filed.
Lordship,
This is regarding non-payment.
Lordship, my please Lordship, this petition has been filed since 2023 December. Lordship, however, there is yet to file their affidavit. So Lordship, if this may be the last chance, Lordship.
Lordship, in spite of several reminder to the department, Lordship, to the state respondent, I'm yet to receive instruction. Lordship.
Then matter can dispose of without filing affidavit also. Then in that case, if you are not receiving any instruction,
I'll leave it to your Lordship. I'll leave it to your
last chance. Okay.
Lordship.
Mm. Miss. Okay. Louisiana Rana Council for that. Repeated reminder. He has not yet received any instruction for filing affidavit. And pray for further 2 weeks.
Lordship.
Time to obtain instruction and to file affidavit. Start. The state respondent is given one last chance to file affidavit. Stop. List this matter after 2 weeks.
Lordship,
Okay.
the union has already filed a affidavit.
Okay.
The union, yeah.
Oh, union has filed. Okay.
Yes.
Okay, Mr. Yangavati Lanet, CJC. For the respondent number 5 is also present. Okay.
Lordship.
May I please, your Lordship?
Yes.
My Lord, I pick the mission item number 30 and 31. Let this matter will come out after a week.
After a week.
Yes, my Lord. Pleading is completed, mail.
This is for hearing only.
Yes. Item number 30 and 31.
Okay. So,
No
no objection.
objection.
Okay, Mr.
That and only, CGST, my Lord. That and only.
Lanet CJSC. Praise for adjournment of the matter for a day. And to adjournment of the matter for a week. To which the Land Council for the petitioner has no objection. Accordingly, the prayer is allowed. List this matter after a week. 30 and 31.
Yes, my Lord.
Okay.
Must make it.
Yes.
May it please, your Lordship.
Yes.
Lordship, I beg to mention here in item number 24 and 25, Lordship, that this matter will be listed after a week, my Lord.
Lordship, can it be on 24th, Lordship?
24th.
Yes, your Lordship.
Okay. On the joint prayer made by both the Land Council for the party, list this matter again on 24th
Lordship.
March.
Lordship.
Okay.
Much.
Much obliged.
For admission, item number 1.
May I please, Lordship?
Yes.
My Lord, here I'm representing for respond number 6 and 7. My Lord, I'm informed that respond number 7 has directed the district land record survey officer to conduct the spot verification of the petitioner. However, the TLRSO has not submitted his report. So kindly allow 2 weeks time to file a report, my Lord.
Okay. Ms. Luciano, Land Council for the petitioner is present. Mr. Tipapong, Land Government Advocate appearing on behalf of respondent number 6 and 7, submits that on the direction of
Respond number 7
respondent number 7,
has directed the TLRSO
submits that the respondent number 7 has directed the DLRSO
Mm.
to make a spot visit to
The petitioner's
petitioner's
land,
lane.
yes.
However, not yet.
He has not submitted a report.
Okay, however, the the concerned DLRSO has
LRSO.
not, is yet to submit report, due to which the counter affidavit could not be filed.
Yes, my lord.
Till date. So accordingly, pray for 2 weeks.
Yes, my lord.
Okay. Further 2 weeks' time. Stop. The prayer is allowed. List this matter after 2 weeks.
Lordship, there is an interim. If
Stop. Para. The interim order passed earlier shall continue till the next date.
obliged.
Okay.
Much obliged.
For hearing item number 26.
My lord, the other day,
Yes.
my contention was that the petitioners have been deprived of their life and livelihood by the illegal possession of the land by the prior respondent without following due process of law as per the Nagaland Land Requisition and Acquisition Act 1965. Because land was taken away by government in 1976 after the enforcement of Land Acquisition Act 1965. Now government, yes.
Just a minute. Land acquisition
Act
applied, act, no, land acquisition,
Act 1965.
we have
Yes, we have shown that day.
65. It was made applicable in the year 1965.
Yes, till now. This is the existing law. This is the law enforced in the state, apart from Central Act.
Okay, so they have.
So in order to acquire land from private individual, they have to follow the procedure laid down under this law, and for that, before they acquire, they have to issue notice to the landowners as per section 7, which they had not done. No procedure has been adopted.
So your land has been taken by the respondent in the year?
1976, madam. 76. Without following any due process of law, particularly the Nagaland Land Requisition and Acquisition Act 1976, 1965.
Act more particularly which, section?
My lord, section 7. Section 711. Section 7 is notice, notice to the landowners, and section 11 is payment of land compensation.
Yes.
Now, if lordship is aware, if we go by the latest law 19 Land Acquisition Act 2013, the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement Act 2013. If we go by the Central Act, which is applicable to all over India except Jammu and Kashmir. If we go by this, even the damage has to be paid, compensation, and for the scheduled tribes and scheduled caste, supposing government has taken the land, government should not take, but in case there is exigencies, government
This is provided under which section?
My lord, as per Nagaland land.
No, under the Central Act.
Central Act. Lordship.
Damages to be paid?
Yes,
Are you claiming the damages also?
Correct. I'm not claiming
Not
damage.
claiming, okay.
That otherwise this is applicable all over India except Jammu and Kashmir.
Okay.
And this is in fact far better, but since we have covered by this local act, so therefore we are claiming the benefit under this local act only that much.
Okay,
Otherwise, quality covered by this.
so,
quota.
this was the Land Act
Nineteen
made
sixty-five,
applicable in the state of Nagaland since 1965.
correct, till now,
So, but the lane, your lane was
Yes. not
Take-
acquired, not
taken by the
acquired,
government
not
without,
acquired
without following the procedure for acquisition
on the land
in the year 1976.
76. Yes,
So when first you made a claim
my lord,
to the government for payment of
yes, we have
compensation?
started making representation.
Hmm.
Annexure. Annexure D1. D1, nah? You see D. Page 20. I have highlighted all the,
This was dated?
this was dated 23 November 2016. I have given this comprehensive representation, showing that in the past also we have made.
So you have made claim over your land and
Yes.
for made a representation only after 40 years.
Yes,
Where you were all these years.
Lordship, as I have shown Supreme Court judgment, even after 42 years,
Also,
Supreme Court have allowed, because they are rural people, my lord. Last time, Lordship, I have shown you, Lordship, 2020 Supreme Court judgment,
2020.
squarely covered.
Okay, 2022 SEC.
2000, SEC 2020, volume 4.
Volume 4. Okay. 2020 and 2024 SEC.
The other one. the other
This
one.
was para?
That one, my lord, this is another judgment. We have another judgment. This
Okay.
is different judgment, same, but 42 years condoned and then allowed. My lord, 2020, volume 2, SEC. Last time, lordship, I have given my
Yes,
lord.
2022 SEC. para?
SEC, page 569, para relevant para 13. This is after 42 years. Supreme Court has allowed land, because in this case also, they have not followed the due process of law as provided under the Land Acquisition Act.
So,
My lord, now therefore, the question before this court is whether this Nagaland state has acquired my land following due process of law as per the Nagaland Land Requisition Act at 1965, which is not. They have never acquired land as per the law laid down by their own state. So therefore, In all the, there are hundreds of judgments passed by the Supreme Court in this kind of cases. Unless the land is acquired, followed the due process of law, High Court, always, Supreme Court has passed several judgments directing state government to acquire the land and pay compensation. Same. But we should cut almost all this.
Yes.
Citation, last occasion we have given. In the last.
Yes,
occasion.
this is there. Let's check. Oh, this is. One is 24, okay, yes. In both para 13.
Both para 13, my lord. SCC 2020 volume 2, which I am referring now. After
Yes,
42 years,
Para 13.
after 42 years, it was condoned. In fact, on the ground of delay and disputed question of facts, High Court had rejected, dismissed the writ petition in this case.
So this is same.
Same, squarely covered. In our case also after 40 years. In this case, Supreme Court after 42 years.
But then here also it appears that because in the state of Nagaland, if this claim is granted, then the entire Nagaland. will
My-
come. So this high court will go by the same, that the high court will dismiss, and then you have to go to Supreme Court.
My lord, lordship knows very well about the civil law. Whether they have any appeal, but lordship will confine only to the within the four corners of the law. And citizens come before the
But it's-
court.
Here in the state of Nagaland, not only thousands, but it will be much more than that, entire Nagaland. And now also claiming it appears.
And my
So
lord,
supposing
that
40
submission,
40 years.
on what basis they are making submission? Because there are gonna be entire Nagaland, there are gonna be 100 cases. There may be hardly any case, there may be case, may not. That is, we cannot have that futuristic and then you do injustice to the victims.
That is there, but here I think there are two persons are claiming,
There are two owners,
two owners.
two
But-
owners.
Uh,
One got grade 4 post that he admit, that fellow admit, and that record is.
That was given on behalf of both the landowners.
No, my lord will see. Naga,
Is there any, whether the land given to taken by the government was divided into two parts?
yeah, we have two, government have given due recognition, there are two landowners. If government recognize these are from same family, then I have no right. But government has fairly admitted in their affidavit in opposition that there are two landowners. And one was given to the other landowners. My lord, government affidavit at paragraph 4, page 2. Very simple and very short, very clear. There are two landowners.
Two landowners.
Yes. Government affidavit. Para 4, page 2. When they have factually admitted that there are two landowners, by giving a benefit to another, one owner cannot deprive the right of other person. May I read it, my lord?
Yes.
Para 4 of government affidavit in opposition, that we regard the statement made in paragraph 2A and 2B of the writ petition, the answering deponent respective state as follows. A, that the total area which was donated by Mr. Nipalo Kafo, this is one landowner, and late Mikalomi, I'm here,
Mhm.
I'm here, Mikalomi. Only this much square feet. So therefore, when government has already admitted that there are two landowners, by giving appointment of grade 4 to Mr. A, B cannot be denied when B is another separate landowner. So therefore, the first issue and the most important question of
So this donated, is donated, it says donated.
this is the word they're using. See, Lordship will appreciate in 1960s and 70s, Nagaland statehood, Nagaland attained statehood in 63. Those days, literate people are very few. Now, when they came to Fitzroy, the leaders of the local people approached two landowners to give their land for the establishment of NST office. So now the law is very clear. Law laid down by the Nagaland government itself in 1965 clearly says that whenever government required to acquire land for development of government offices, government has to acquire and then pay compensation. Only then government will be happy.
With the other one landowner is Naipelo Kafo.
Yes, he has been given.
And you are son of late Mikhalomi.
Correct. Now my father died, my brother, one of the petitioners died. I'm the only surviving person.
So out of these 26, 13,900 was acquired on payment of compensation.
Yes.
So what remains is 14
Yes.
square feet, 14,000 square feet. And this 14,000 square feet belongs to these two persons, you mean to say?
My lord, in my read petition, I have listed paragraph 2, my lord, read petition. I have given a clear chart how much land I have donated and how much land has been donated by another gentleman, my lord. My read petition, paragraph 2. Paragraph 2, my lord.
Yes.
My lord. The short facts of the case in hand is that sometime in the year 1976 and 1977, the Nagaland State Transport Department, Nagaland, entrusted the town committee public leaders to search a suitable plot of land for establishments of Nagaland State Transport Office, staff quarter, garage, and parking area to be acquired by the department. Accordingly, Sri Yehuse Duren, late Zoni Letu, and late Puninu had approached the petitioner's father, late Mikhalomi, and other landowner, namely Nipelo Kafo, for donation of 232 into 149 square feet area of land for the said purpose. Therefore, the petitioner's late father had donated the land measuring an area of 132 into 82 square feet situated at Ketupa Colony, Fitzroy Town. This is the area I have donated, my lord. My family had donated because they approach. Now, therefore, though the petitioners as citizens are illiterate and ignorant.
So this, you are also admitting that it was donated.
They have taken.
You
They
said-
may be using the word donation or contribution or.
Then you yourself have said that it was donated.
Yes, they're using the word. But the law is clear.
No, you are also using the word donated.
Yes.
Father had donated.
Yes. For the establishments of the NST garage and offices.
Yes. Then
So now, when the law is very clear in 1965 for land acquisition, when the government has not followed and deprived the right of the citizens, court judicial interference is always called for and always pass order to protect the right and interests of the citizens as enshrined under Article 300A of the Constitution of India, and also particularly the Land Acquisition Act 1965. And that in 1976-77,
If the land was donated by your father, can you claim for compensation then?
next sub continuation para
Okay.
para 2A.
Hmm.
That there was an oral agreement between the Department of Transport and the petitioner's father, late father, on the terms and conditions that if the petitioner's father donated the land to the department, an appointment of grade 1, grade 4 post, oblique land compensation, or any contract work for the land acquired by the respondent would be given to them. So in all over Nagaland, Lordship will see 1960s, 1970s, no written agreement, wherever it is. So government approached them, Naga people in good faith, they, okay, you take the land, but give me money. You take the land or appoint one of my children in lieu of land compensation. So in the present case, government came, approached with the local leaders, whose name we have mentioned in the writ petition. They approach, or we say, okay, if it is for government, but for the welfare of the state, will not oppose. But that does not take away the right of the petitioners as citizens without following due process of law.
So let us see, what is the total area now comes, your part is?
My area is
232 into 1.
into 82 square feet.
82 square feet.
Total area, how much it comes into? Right?
So how much it would be, say?
That's why into, right? How much it comes?
Anyone having? Okay, it comes
Into, how much it comes, total area?
4, 6, 1.
$10,800.
9,728
10,824 square feet.
square feet.
Total, yes, total. 10,824
So
square
this
feet.
would be around how many square meters? Say around. Say around 3,000. So you are supposing if the compensation is to be paid, it has to
Yes.
be at the rate which prevail at that time.
Well, according to the now, not at that time. Now it'll be in the form of now it'll be in a present market rate now, because till now they have not paid. If the award was settled way back 1976, yes, it'll be the rate of that time.
So now what is the, how do you justify
No, that
that
not,
it was, say it was a donation and then you have no record of any agreement between your father and the government for providing any job.
the government has
So how do you justify the donation after giving donation by your father? You can claim back the land or the compensation,
lordship,
because it's not a case that it was taken without your knowledge.
no, that it cannot be.
It cannot
If
be.
it is without
So
my,
it was no written agreement, nothing, no document at all.
if it is
But,
without lordship will, if it is without my knowledge, it will be trespass. There'll be a criminal
Right,
case.
right. So It was donation. You say, you yourself says that your father has donated.
The layman,
Hmm.
the layman, whether they use the word donation, sacrifice, contribution, that does not take away the right of the citizen. The
Because
only
if it is,
question,
if it is a donated, or if the person donates the land, so acquisition may not be required, or what? Or
no,
still the
no, why,
acquisition-
why
still
not?
the acquisition will be required.
Acquisition, definitely. That's why I'm saying, my lord.
Hmm.
The only law to be decided in this case is, as I have shown the Supreme Court judgment,
Hmm.
the only aspect to be examined by High Court is whether the state government has acquired the land following due process of law laid down in 1965. If it is not,
Hmm.
in all the cases, Supreme Court as a High Court directed, state should acquire following due process of law and make payment. Owner, not the owner, cannot claim the land because this is for the welfare of the state. And here also, owner does not claim back the land. The only question is, why taking due advantage of my father? Ignorance, illiteracy. You have taken money for the last many years, and now, till now, you have not acquired my land legally. My lord, lordship, as we have read the judgment, it is very simple that in every case where land is not acquired following due process of law, Supreme Court and High Court, their only duty in Supreme Court, High Court is to see whether state government as welfare state has complied the due process of law. That much. If they have complied, the petitioner has no case. If not complied, then state should be directed to acquire the land in terms of the prevailing law and pay compensation. That much only. The rest,
You are Mr. Your owner name is
my lord, I am the
Mika.
Mikalomi is my
Mikalomi.
father.
And you are
Wekupe,
Medongulo Lomi.
yes, Wekupe and Medolomi.
Who is this Wekupe?
Wekupe, we are two brothers.
Okay, both are claiming.
Both are brothers. Elder
Now,
brother,
the both are petitioner here.
yes. But unfortunately, when the writ is
Okay,
pending,
okay.
the petitioner number one again passed away. So the father could not enjoy the fruit. Even the elder brother could not enjoy the fruit. The only second, the last child is surviving.
So he expired during the pendency.
Yes, very much. We have brought to the notice of the court also.
Okay, so there is a record
Yes.
by this court also.
Yes, already. We have brought to the notice of the court through affidavit also. So now the only surviving person is petition number 2, Medongulolomi.
Now there is agreement, you have seen. Para 19, the type copy. is para 19, page 19, your writ petition.
Yes, my lord. Page 19.
This is by the landowner. Lomi is also there.
Para 19.
Kindly read page 19,
Yes,
agreement.
yes.
Hmm. Can we just read it?
Para 19.
Yes, no, page 19.
Page 19.
Hmm.
It is agreement. It
Hmm.
is hereby agreed upon that the plot acquired for the purpose of constructions of substation building and staff quarter, etc., by the Nagaland State Transport Department at Procedural would be free of all encumbrances. Since the NST department has already fulfilled the condition like payment of land compensation for the acquired cost of shear leveling and appointment of one grade 4 staff from one of the landowners. In confirmation of the above, we do hereby sign on this 5th day of March 92, signed by V. Sekwase, General Manager, Nagaland Transport.
Hmm.
Then witnesses, Mayelo Kapfo, Vice Chairman for Shore Town. Nipelo Kapfo. Nipelo is one of the landlord who had got the appointment. Who had got appointment. Number 2 is.
Yes.
Then number 3 is Ngupel Hilomi. He is not me. Number 4 is Ngulo Kupo. It's not me. Petitioners are not here.
Then who are these Lomi? Mupeli.
There are the clan members, supposing in Nagaland.
It says landowner. It says landowner.
No, no, no. My lord will see. Supposing Jamir Nagaland. Jamir.
Huh.
Jamir spread to all over our areas. Jamir, Mr. Jamir. Example, any title for that matter. So therefore, that does not mean that all the Lomi will be the family members of the petitioners.
No,
Lordship-
so because probably they made a claim and on being claimed, probably this was fulfilled and paid compensation and also appointed. So thereafter, this was signed, this was executed in the way back in the year 92. So now we do not know who is this Lomi. Lomi signed as a landowner and cannot be false person because it was involved with the government also. The responsible person and public leader were also there. The other landowner was also there.
The other landowner is the one who has been given grade for appointment.
Hmm.
Nipelo Kafo, serial number 2. The rest, Ngupel Hilomi, Ngulo Kupo.
Now see, if you say that this agreement was behind your back and
Yes.
it was not signed by you and you are the main owner, the actual owner of the said land, then you see there will be a contest between Lomi, Ngupeli Lomi, land who claim to be landowner and signed this agreement. He has already signed.
Whether Ngupel Hilomi is the petitioner or not, my lord. He is not the petitioner. Therefore, any undertaking, any agreement signed by a stranger has no binding
Now,
of
now,
the
in that,
petitioner.
now in that case, probably you need to establish that land belongs to you.
My
Because
lord,
the other person has come already and accepted.
other person will obviously accept because has been given appointment.
And
That is what
not-
we have studied in the.
there are not
report.
only one, but two landowner shown here.
No, there's no only one. Number 2 is the landowner. The rest are not landowners.
And then your town committee chairman also has signed, even the public leader, because they knows best who the land belongs to whom, who is the owner of the land, and that is why.
My
It
lord,
appears that I have accepted.
lordship knows that any agreement undertaking executed by other person
Now-
other than the
Now
petitioner
this is
has
your-
no binding.
Now this is your document.
I have annexed to show that.
Yes.
Now
not
I'll
from-
show
Not from the outside.
the,
Because it appears that you have come to know that one Lomi has also accepted the offer and accepted that it was already paid and it was in consideration of the compensation paid, the land was taken. So then when it comes to know that some Lomi has signed, which is not you or not connected to you, then you could have lodged complaint against Mr. Lomi.
I'll take lordship.
Hmm.
For that, I'll take lordship to page 32, 23, where the same Lomi has sworn this affidavit. May I read it? Page 23. The same Lomi has sworn this affidavit before the competent authority. That's why I'm just taking slowly.
Hmm.
Annexure D2, page 23. May I read it?
Yes.
The same Lomi, okay. Ngupel Lomi, the same person who is allegedly signed.
Hmm.
I, Sri Ngupeli Lomi, aged about 65 years, son of Wallo, resident of Seed Farm Colony, Fachoro Town, Pak, Nagaland, do hereby solemnly affirm and declares as under 1. That I am a bona fide citizen of India, hailing from Leshimi village under Pak district and presently residing in the above mentioned locality. 2. That I am the brother of late Mikha Lomi, my father's brother, who is the owner of land acquired by Nagaland State Transport NSD Department at Ketupa Colony, Fachoro Town, measuring 132 feet in length and 82 feet in breadth. However, this land which was acquired by NSD Department is his self-acquired property, and he is the sole owner of the above mentioned plot land. And I have never entered into any written agreement with the NSC department with regard to the above mentioned land plot. Hence, the issue of signing any written agreement by me as a party pertaining to the above mentioned plot/land with NSC department does not arise. 3. That I have no knowledge whatsoever of the deal agreement entered between the landowners and the department and any persons authorized by the department with regard to the above mentioned plot land, as I was not a necessary party or even a performer party. 4. That the contents of this affidavit made in para 1 to 3 are true and correct to the best of my knowledge and belief, and nothing material has been concealed therefrom. And I signed this affidavit before the competent authority in July 2015 and I signed this affidavit before the competent authority on 21st July 15 at Fachoro, Nagaland, signed by Ngupel Lomi, signed before the notary public. So there is one. Then next page, my lord, another signatories, page 24. I, Sri Ngulo Kupo, aged about 62 years, son of so-and-so, resident of Seed Farm Colony, Fachoro Town under Pak District, Nagaland, do hereby solemnly affirm and declare as under that I am a bona fide citizen of India, hailing from the Lasumi village under Pak District, Nagaland. That I have no knowledge of how the land was acquired by the NSC department at Ketupa Colony, Fachoro Town under Pak District, Nagaland, as I was not a necessary or an interested party, nor have any connection with the land acquired by the NSD department. Therefore, as stated, I was neither a party nor a witness to any written agreement, if at all entered by the necessary parties. Hence, the issue of signing any written agreement pertaining to the above land by me never arises. It is pertinent to mention that I don't know how to sign at the relevant time in issue, as I have never studied or attended school. He's an illiterate person. His signature has been shown. That the so and so. So this also signed by Ngulo Kupo, who whose name appear as serial number 4 in the so-called agreement.
So
So
this-
therefore, the so-called agreement is
Mulu Kupo is also,
signatories, stated to be signatories.
he is a signatory.
Yes. There he has stated that I'm an illiterate person. How can I sign my signature? I have never
But
studied.
he accepted that he signed it.
No. My lord, that's
Oh,
what
he did not sign,
he
sorry.
did not.
Never studied.
Never studied. So
Okay.
therefore, how can he put signature? Beautiful signature. Serial number 4. If
Now
we-
then, these two person, whether these two person has lodged FIR
no.
for forging
No,
their signature.
that I have no information about that because we were not with them
Now
earlier.
it remains inconclusive then. Now it's on, the affidavit is only his own declaration. But this document is signed. So unless they file FIR for forging their signature, then only declaration, will it help just? Will it help? Only just declaration later on. Subsequently, declaration that I did not do without lodging complaint.
I leave it to your lordship.
No,
Lordship may pass any
I'm
order.
asking you, I'm asking you, you're expert.
No.
Uh,
My only submission.
You have been
before
dealing with the criminal cases so long, so you must be knowing.
Of
So that's
course,
why I'm
of course.
seeking
No doubt.
uh,
That part. I
so
agree.
because this is only declaration. His own declaration before
No, my
that.
lord, this is
Declaration can be done anything.
declaration, unless this declaration is nullified by another order, it will remain. Nobody has challenged. This is in the know of the
No,
government.
it hasn't come to the knowledge of this authority who has signed. It hasn't come. No, it hasn't brought to the notice of this government where
No.
with whom this agreement still is, I think, lying.
My lord, you can pass any order, my lord. No problem. No problem. My only contention before court is question of law only. Whether government has acquired the land following due process of law.
No, that is true.
If that is finalized.
That is true. But
If court come to a conclusion that yes, they have acquired the land
there you
following
are
due
correct.
process of law.
There you are
Finish.
correct. Agreed. There you
Or-
are correct.
Or if court come to a conclusion that they have not followed due process of law laid down in 1965, then matter also.
No, there
Different.
you are correct. I said because only this donation would attracted me. And then this agreement. And here in the agreement, both the landowner have signed that it was donated.
My lord,
And
not
then
land
compensation paid. Compensation paid.
My lord, I'm repeatedly trying to correct that statement. Petitioner has not signed the affidavit, the
No.
agreement.
No,
Petitioner has not signed the agreement.
so that is why I'm asking you that only denying the signature put before or put with the government, executed with the government authority, that is general manager, and in presence of the chairman of the committee, town committee, and also public leader, only in the way back in the year 92. Can you just, in the year 90, after say around 13, 14 years, can you just by merely a affidavit without lodging any FIR, can it be treated as a valid, or can it nullify the agreement which was?
Vice versa, my lord. I'll put a question to all of us.
Yes.
Any agreement not signed by me, can it have any enforcement on me?
Cannot.
No binding.
No, it
Then-
cannot.
The same
Cannot.
thing.
Cannot. But then you have signed. There is
No,
a
I have not
record-
signed. That's what I'm saying.
There is a record you
Agreement-
have signed.
my
If
lord.
you have not signed,
Lordship will.
and if you have not signed, if you are making an allegation that your signature was forged,
No,
then your
see-
duty, that it is your
No.
duty that lodge a FIR that my signature was forged, and by forging my signature, they have accepted this signature, this agreement is still there, wherein you have admitted that their compensation already paid.
My lord, I'll,
Because now you are trying to now you are claiming compensation, trying to claim compensation, nullifying that. So that unless that is nullified legally.
My lord,
will it
allow me to
Yes,
clarify about
please.
that.
Mm,
Allow me to, if I'm wrong, correct it.
Right, please.
There are two petitioners.
Yes,
One is one is Wekupalomi.
both are here.
No, no, also I'm coming.
Mm.
Allow me to clarify. Wekupalomi is one. Medongolo Lomi is one, two. Here, there are no signatories here. In the agreement, both of them are not signatories. If that fact is corrected, then Lordship will appreciate what I'm saying. Where Cooper Lomi is one petitioner, he died now. Then Medongolo Lomi, he is not a signatories here. Neither Wekupa Lomi nor Medongolo Lomi, they are signatories in the agreement. When there are no signatories, what authority, what right they have to file FIR? This is my point. If Lordship understand that, fine. Otherwise, I have no further agreement. My Lord.
No.
Because you see, Lordship have seen
You-
agreement.
You yourself have submit that this Mupelhi Lomi is the brother of your father.
No. My Lord will appreciate.
Hmm.
Here, the signatories. One is Melokafo. He is not petitioner before this court. Nipelokafo, he is not petitioner before this court. Ngupel Hilomi, he is not petitioner before this court. Then number 4, Ngulo Kupo, he is not petitioner before this court. So they are not agreed. I don't know. I'm supposed to know only what I have done. I am supposed to know only the action on my own. Therefore, when the petitioner has not signed the agreement, this agreement has, right or wrong, this agreement has no binding on me. That's what I'm trying to say. My Lord, that is my contention. If Lord receive
Now-
come, fine, no problem. Otherwise, no problem.
Nipelo Kapo
Yes.
is another lane owner.
Very much.
Lordship, let me intervene in that. In the writ petition, petitioner number 1 is given as 44 years of age. 44 years of age. That is, petition is filed on 2019. Last part of 2019. And the petition now expired, and the petitioner number 2 was only 39 years. That is, and petition was filed in 2019. So now if we do it, one who was having 44 years, when the agreement is signed, he might be 18 years. Petitioner number 1. But we hope, I have not verified that, but the person who was signed,
Just 1 minute for that.
the
Just one. I'll sit down. We are talking about agreement signed in 1992. I keep telling I'm not a signatory there. So agreement 92 has nothing to do with me because I'm not a signatory. That's the point.
No.
so now what the learned Fred is saying might be petitioner's father's brother might be. I have not verified that, but by applying common sense, we can come to that. Your Lordship, let me come to my submission will be very brief.
Yes.
Lordship is aware that Nagaland is under special provision of 371A, wherein land and its resources is protected, not unlike other states. Land and its resources is something which is only given to the Nagaland, not to Mizoram, Arunachal, or any other state. So that is why the prayer of the petitioner, Lordship, may you please come to the prayer portion of the petition in this writ petition. You'll find Lordship in page 18 and 13. The prayer of the petitioner in this writ petition, and I'm taking your Lordship here so that your Lordship will be
Prayer
able to-
of the petitioner.
Yes,
12.
you'll find in page 12,
Hmm.
13 of the writ petition.
Yes.
I'm coming to this so that your Lordship will able to fairly comprehend the metrics of the case. The prayer, number 8, direct the respondent to acquire the land as per the Nagaland Land Acquisition and Acquisition Act 1965, Land Acquisition Act 1994, and right to fair compensation and transparency, and Land Acquisition, Rehabilitation and Resettlement Act 2013. That is one. And so far as land acquisition and requisition 1965 is concerned, we admit that we have, at the time of the transaction, we did not apply this act. That is we are admitting. We have not acquired the land on the basis of the provision of that act.
Yes.
That is we are admitting. Now, number 2, and so far as the Fair Compensation, Transparency and Land Acquisition, Rehabilitation and Resettlement Act 2013 has been concerned, there's an act passed by the Indian Parliament. So this, as my friend has rightly pointed out, it is not applicable applicable to all the states in the country except state of Jammu and Kashmir. I agree to that. But this act has been put into this before this court, and one reverse Susang case, and then court has given a judgment, and then it is under consideration before the division bench appeal. I was not a counsel for that because Nagaland is protected. So Land Acquisition, Rehabilitation and Resettlement Act 2013 should have to be assent to by the Nagaland Legislative Assembly. And so far, because Lordship is well aware 371 stipulates that anything affecting land, ownership of land and its resources passed by the Parliament must be assented, given consent by the State Legislative Assembly. Only then it becomes applicable in the state of Nagaland. Since this law is directly affecting the ownership of land and its resources in the state, say land in the state, it will be by common sense, cannot have an automatic application in the state. Cannot have an automatic application in this state. And so far, this act has not been given assented to by the Nagaland Legislative Assembly. Now, and so far as your lordship,
So this question is.
so this act is not applicable.
This question, according to you, is lying pending before the division bench of this court.
It has not been disposed of. It was contested. I was not the counsel for the state, but some of my colleagues were there, and it was still not decided. It was, I think, pending in the division bench.
Raising the same question, applicability.
Applicability of this
Land
act
acquisition.
was come before this court. So it is pending. I'll try to find out what is the position now, but it is pending. That is the information. Now, your lordship may come to C. Direct the respondent to consider the existing landowners scheme notification dated so-and-so 5th March 2018 implemented in the state of Nagaland. Lordship, you'll find there is two prayers. Lordship, you will find the scheme, March 7, 2018 scheme. Lordship, you will find this scheme, Lordship, you will find in page 34 of the writ petition. Page 34 of the writ petition, 3-4. I'll take your lordship to the relevant portion only.
Yes.
Lordship, me, please come to para 2. Para 2. May I read your lordship?
Yes, please.
All para 2.
Yes.
All cases where administrative headquarters and block headquarters are set up in various parts of the state on land donated freely by individuals, villages, or bill of that area should not be reopened for compensation or for employment in consonance with the policy brought out by so and so, 1977. So now this is the latest OM holding the field issued by the authority of the state. That means number 3A, I'm coming to number 3A, Your Lordship. And in other cases, prior to 26/7/2005 and subsequent to setting up administrative and block headquarters on freely donated land where a specific written agreement exists, providing for employment to the landowner, the claim of the landowner for employment should be settled in terms of such agreement. Now, this has been done in our case at hand. Now, Lordship, the most important one, I'll come to 3C, the last para. It is also clarified that it is not the policy of the government to provide employment to the landowner in perpetuity. The employment of the landowner, if permitted by verifiable and valid agreement, is entitled to the person first appointed as landowner in government service and does not entitle his descendants for further employment on his retirement from service. After the appointed landowner retires or vacates the post, the vacancy will be filled up through an open advertisement in consonance with the existing policy, giving equal opportunity to all applicants. So that is the standing policy. So department is working on that, following this standing policy. So now, Lordship, as I said, Lordship is kindly turn to again para 2 of the writ petition, which my learned friend has pointed out. It's very important.
Para 2
Para 2
of the,
writ petition.
yes.
I'm reading, Your Lordship. The short facts of the case in hand is that sometime in the year 1976 and 1977, the Nagaland State Transport Department, Nagaland, entrusted the town committee public leaders to search for a suitable plot of land for establishment of Nagaland State Transport Office, headquarters, garage, parking area to be acquired by the department. That means that is, Your Lordship, 48 years back. So during that period of time, Your Lordship, there were hardly any educated people in that area. Accordingly, Sri Esho Doring, late Zoni Leto and late so-and-so has approached the petitioner's father, late Mekalomi, and other landowner, namely Nepelo Kafu, for donation of so-and-so square feet land for the seed purpose. Therefore, the petitioner's late father had donated land measuring so-and-so. Number 2A, that there was an oral agreement between the Department of Transport and petitioner's late father in terms and conditions that if the petitioner father allowed the donated land to the department and appointment upgrade for both land compensation or any contract work for the land acquired by the respondents would be given to them. Lordship, that is the thing. Either appointment, grade for both, land compensation, or contract work. Either one. Either one. This has been orally agreed between the petitioner's father and the department authority.
Now that is.
Now, Your Lordship, I'll come to that.
Now, just a minute. Now this is oral agreement, Mr. Job. You say that it was oral agreement.
Yes.
Nobody is there to prove also. Nobody is there to tell about that. At that time, you were not nowhere, probably. So this is again difficult to prove also. Oral agreement, what you submit, because there is nothing on written. Written is only the agreement that you have already received, 1992. where you have just, it was reiteration of the, probably the early, if there was any agree that you have already received. Probably it appears that there was some oral agreement and subsequently paid, compensated, appointed. So that is why this 92 agreement was executed. It appears. Yes, sir. So you were to, yes.
I'll come to that.
Hmm.
So in order to substantiate that, Lordship, may kindly come to para 4 of the state affidavit in opposition.
Yes.
Para 2 of the writ petition, I just read out now my reply. That with regard to the statement made in paragraph 2A and 2B of the writ petition, which I just now read out, the answering deponent respectfully states as follows. That in total area, that the total area which was donated collectively by Nipilo Kafu and late Mekalumi is 2,000
26,000.
26,000 so and so square feet, such and such. And out of them, 13 so and so was acquired on payment of rupees 13,900. It was that time, 70s, it was a huge amount. Further, the deponent begs to state that the contract work award was awarded to the petitioner, Mr. Wigme Lomi, for construction of maintenance center of 05 or quarter number 21/3/1991. That in the year 2011, appointment was given to Sri Nipulu Kovi as mechanic helper by the office orders so and so. That is dated 10/3/2021. Lordship, you will find the appointment order and the contract order and page 4 and 5 respectively. Lordship, kindly peruse this.
Yes, that is there. 1 minute. Contract work you were to produce.
Contract work is also there.
Is there?
It is very ineligible. But that is this is that of in 1991. So giving in, they could not produce the original copy, they send it through WhatsApp. So it is like this.
Okay, this is contract work. Page 5 is a work order.
Yes, this is a contract work order given in 1991 to the petitioner. And then one is the appointment.
Yes.
Given to the first landowner. There are two landowners.
Appointment, whether this appointment order have you annexed here? Probably.
No, Lordship, you will find. Lordship, you won't find the appointment order. You will find in my page 4 that I just given to you.
Yes, yes.
Yes, you will find in page 4 the appointment order.
John Kapoor, son of, Nipulu Kapoor. This is to the another landowner.
Yeah, another landowner.
Okay, and then this is the
it's given to
contract work to the present petitioner.
Yes. It is
Lomi.
with Kopi Lomi. Contract work was given.
Bring this on record. We'll dispose of. Bring this on record by filing additional.
I can do that. I can do that. Because this is WhatsApp.
This is to be brought on record.
So insofar as in compliance with the notification, latest notification, which is holding the field in Nagaland, state has fulfilled all the
As per the agreement.
as per the notification.
I think
that is
you-
March 5, 2018.
Okay, you have to file it.
Now I'll come to the point of the limitation. Roshmi, kindly see. the petitioner is approaching this fall
Hmm.
after 48 years. Because whatever was happened and that is last part of the 1970s, 1977, 1976, like that. What should we come to limitation? Lordship, you will find. That is why I'm saying, without going into the merit, this petition must be dismissed for want of limitation. Yeah, 2024.
Yes. Hmm.
Lordship, you will find in schedule.
Schedule of
page
limitation.
30. From page 30, that is, section is there. This schedule you will find. Lordship, section. Schedule. '72, your Lordship, 72. 11 for our case will be 72. Schedule 72.
Yes.
For compensation for doing or for omitting to do an act alleged to be in presence of any enactment in force for the time paid in the territories to which act is stated. That is only 1 year. That is only 1 year. Now see, petitioner was there. Father was there, he was there. They are coming after 48 years. Something which was done in 1976, 77.
This is suit relating.
So it is squarely backed by the law of limitation.
This is suit relating to torts.
My learned friend is saying that the state government could have acquired the land as per the provisions of this dictates mandated in the Nagaland Land Acquisition and Requisition Act 1965. But after 48 years is coming. So without going into the merits, your Lordship, my respectful submission before your Lordship is, without going into the merit, since the petition is bared with law of limitation, on that score alone, this petition needs to be dismissed in the interest of justice. That is my humble submission before your Lordship.
Okay, you file this, bring it on record, this in affidavit, bringing it on record. The document which you have produced today. Okay, the appointment earlier, it was not produced. Additional affidavit. Or you want this matter to be disposed of on the basis of the document produced for you?
Yes.
Okay. So then, anything more? Yeah, have you seen?
My lord, the document produced by my friend is not legible at all. Whether I can read my name here. Number one, on which date? Then if we see the reference, your tender number, nil.
Okay, you, then file in affidavit, type it out, get it, type it out, file in affidavit.
And then,
Okay.
see,
Okay,
I don't, yeah.
after hearing, sorry, where is,
Lordship, I'll be needing to take some time if my friend agrees to file the affidavit.
take some
Because
time.
people are there and pack very long, administrative officers very busy. They have to come.
So hearing otherwise complete.
Hearing otherwise complete.
complete. So since it's not legible,
If
so
lordship
he'll
can,
submit a type copy.
if lordship can accept this one, I have not, but according to me, it's not legible. How do I understand?
Hmm.
The reference work order number is nil, and nothing is here. So anybody can print
He'll
out,
consult the officer concerned.
do
Consult
that.
the officer concerned
No
and
problem.
get it, type it out.
I have no problem,
Okay.
because they have to, not only
Let us be
this,
fair. Let
not,
us give
not
opportunity.
only this,
Uh.
if this is the work order, they have to show the how much, what is the record? Record should be produced. I want to see really whether, because that time I was a minor, I have filed affidavit. I have annexed my birth certificate also.
Okay.
How can they issue work order to a minor that time?
Let us see if it is, if this is really your name.
Yes.
If
Okay.
your lordship want to see the records,
Hmm.
I can call the record.
Or record, no problem.
That is
That is,
also no
that is the
problem.
good part.
Okay.
Very good.
Okay.
Or else, if your lordship
uh,
wants me to file an additional affidavit, bringing in
no, no,
record,
see this,
that is
bring
also
this on
possible.
record, and then if required, you want to see the record also. I think
Lordship,
if this, we get the clear on the legible copy of this order, I think that should be sufficient.
my lord, not only this order,
Hmm.
lordship, I don't say anything now.
Hmm.
Whether there's any record of such, I doubt.
Okay.
Because that time I was just a minor. Number one. Number two, if this is the work order, what kind of work was that? Then whether there was any completion certificate of that time. Because if they have this, they should have the record. I want to see the record.
Yeah.
Hmm.
If the work order was given and then if he have received the
And,
bill, I think that should be
my lord, that's why I'm
sufficient.
saying, I keep saying I have filed affidavit annexing my birth certificate issued by the company authority. So therefore, there's fishy in this case. They just want to overcome that they have not followed the due process of law. Only simply they are trying to mix up. Anyway, no
After
problem.
hearing, okay, heard Mr. Joe, Land Council for the petitioner, also heard Mr. Okay, just the land, senior government advocate, huh? The Mr. Moore, land senior government advocate, placed some documents. Place some documents, including the appointment of one Mr. John Kafo, son of Sri Neipelo Kafo, and to the post of mechanical helper, and also work order issued to
Father of the
the
petitioner.
father of the petitioner. It's a father of to the father of the petitioner. Okay, to the to one Sri Wakupe Lomi. And and prays that he may be allowed to bring these documents on record by filing additional affidavit. The prayer is allowed.
And my lord, meantime, if record also can be called for, the
Prayer
relevant
is allowed.
file,
Prayer is
so
allowed.
that all of us
To
will
the-
be satisfied.
Okay. List this matter. Again, when can you? So on which date you will also produce record?
It's up to you. When can you file affidavit?
When can you file?
Only this week, not possible then. Not possible, only this week. Next week is not there. No.
You want this matter to be taken up by this court? Then I am coming after 2 weeks.
Yes.
In
As
the
per
month of
the-
April.
As per the
After
roster.
2 weeks, after 2
Okay,
weeks.
this matter after 2 weeks. On which date the learned senior government advocate shall also produce the relevant documents.
Yes, relevant record, my lord.
Relevant records, connected to with, connected to the issuance of work order. Okay,
And meantime, in case I find it necessary to file any reply, I may be given,
okay. The,
because these are
Petitioner.
new facts.
okay, the petitioner is also at liberty to file
Counter if any.
counter, reply to the affidavit, reply to the affidavit to be filed by the government, if so advised. If required, huh?
Yes, if required, that's all.
Yes, sir. This also keep along with, and then this. this one. Okay. Because this probably, this case if decided, will be a leading case.
My lord. I
Therefore, we have
understand.
to be very careful.
I understand lordship's opinion also. I understand. I have an, I appreciate that also. I agree. My lord.
Collaboration.